State.
My Lord, Honorable Assessors, the matter is at the stage of a pre-sentence inquiry in terms of Section 146, SI 146 of 2023. The state is ready to proceed.
My Lord and learned assessors, as indicated at the last hearing, the accused persons wish to make an oral application. We had indicated at the last hearing that there was an option of putting it in writing. We are not then able to put it in writing. We then decided that we would make an oral application. We filed a notification to that effect this morning, but I think it has not yet been approved by the registrar. It is.
I have seen it.
Thank you, my Lord. So that was the notification that we would need to make an oral application. We would be very brief. With the indulgence of the court, we had decided that it will be a joint application. I will make the presentation on behalf of the both accused persons, but with an addition from Mr. Jeter.
Yes.
Thank you, my Lord and learned assessors. We are making this application in terms of Section 4 of the sentencing guidelines as read with Section 69(1), subsection 1 of the Constitution. We specifically put on record that there is no express provision in the sentencing guidelines that would provide a procedure for an application of this nature, in effect for any application.
You said there's no express provision?
There is no express provision in the sentencing guidelines which sets out an application procedure. But we proceed on the basis that the application that we are making is an application by accused persons to be facilitated in their preparation for mitigation and responding to the aggravation by the state. And that facilitation be by being given a copy of the written judgment of the court that was read orally in court on the day that they were convicted. So we are making a distinction between the judgment that was pronounced in court and the written form of that judgment. We are applying for the availability of the written judgment of the court. And the basis that we are making is that that written judgment is essential for the processes that the accused persons would get to engage in at the pre-sentencing stage. Now, having said that, I wish first to make the point why we believe that Section 4 does permit an application of this nature. Section 4 is very simple. It makes it clear that the sentencing guidelines apply to the courts that are listed there. Supreme Court, High Court, and the other courts. I would read the section. It's very simple. These guidelines shall apply to all criminal proceedings in the Supreme Court, High Court, Magistrate Court, or any other court specified. Our submission is that by necessary implication, and in fact, not just necessary implication, but by an unavoidable implication. That section allows an accused person to make an appropriate application to a court to be facilitated. In other words, whatever can be made available to an accused person so that they exercise the rights that are given in the guidelines, that application can be made. And that is the basis. And we say so because the guidelines actually give rights to accused persons. And our basis is that where a right is given, a remedy is implied. I think the Latin expressions ubi ius, ubi remedium. Ubi ius, ubi remedium. Where you give, like you say that these guidelines are binding on the court, and you are a beneficiary of the guidelines, and there's something that you do not have which you believe you require for purposes of accessing the rights, you are entitled to make an application to court. And this is the application we are making. And we have said that it is then read in the spirit of Section 69, subsection 1 of the Constitution. That section gives the accused persons a right to a fair public trial. I think it's a familiar section. I may just read it for the sake of completeness. It says that every person accused of an offense has the right to a fair and public trial within a reasonable time before an independent and impartial court. We make reference with a specific issue, my Lord and Land Assessors, to the fact that the word fair is separated by end from public. In other words, there is such a thing as a fair trial on its own, a fair trial. And the application we are making is about realizing a fair trial. The accused position is that without sight and studying and scrutiny of the written judgment as opposed to the pronounced judgment, they will be unable to access.
Sight.
Without sight of the written judgment as distinct from the pronounced judgment, which was an oral presentation by the court.
Yes.
They will be unable to do proper mitigation. And they will also be unable to respond adequately to the submissions by the state on aggravation. My Lord and learned assessors, they will go further then to say that that inability, that being disabled, would then render their trial not fair within the contemplation of Section 69, subsection 1 of the Constitution. We will explain very briefly the disadvantages that the accused persons will face in the absence of the written judgment. I was initially just saying what is the basis, the legal basis for the application is a necessary implication from Section 4 as read with that provision of the Constitution. And also in view of the fact that where a right has been given, a remedy is implied, ubi ius, ubi remedium. So in saying that these guidelines are mandatory, that is a very specific right given to accused persons. It necessarily gives them a right to make an application. Now, having said that, I then move on to the fact of the circumstances surrounding the application. The circumstance surrounding the application, my Lord and learned assessors, is that at the time of the reading of the judgment, there was an indication from the court that the judgment would be uploaded. And that was not the only thing. Then there are also subsequent events where the accused legal representatives had requested, and a letter was written by the registrar, which specifically promised or made an undertaking that the judgment would be uploaded. I think the date that was given there was 10 November. I would stand corrected that the judgment would be delivered. I think handed down, uploaded on a Wednesday of last week. Now those are the circumstances that are surrounding it. And then further, my Lord and my learned assessors, there's a difference between, we did take notes, the legal practitioners for the accused persons did take notes during the reading of the judgment, but the accused persons themselves did not take notes. They didn't have sufficient facilities to take notes. We specifically submit that even though the accused persons are represented, they do have a separate participation in these proceedings. That separate participation requires them as accused persons, not necessarily their legal practitioners, but as accused persons, they would be in a better situation where they are also reading the judgment. And then they are able to give sufficient instructions to their lawyers. They cannot, in this situation, rely on the notes of the lawyers, which have also turned out to have so many gaps from the reading of the judgment. I'm just putting, this would be evidence from the bar. But it's important that the court takes into account that the accused persons themselves did not take down notes. There were no facilities for that at the time that the judgment was read. They would benefit from this. Then I want to refer the court to the specific provisions of the sentencing guidelines, which would require what we are requesting. And first, I make reference to Section 9 of the sentencing guidelines, which relate to mitigation. And I refer to Section 9, paragraph K, which is that's what is most important for the accused persons. It is that's paragraph K. That's the first paragraph I wish to refer to. Paragraph K says that in mitigation, the accused person may rely on evidence that the offender played a minor role in the commission of the offense. What is very unclear to both accused persons, I'm making the presentation to both accused persons, it is from the reading of the oral judgment, it's still very unclear the extent to which the degree and the extent of their participation, how it was dealt with by the court in its convicting judgment. My Lord, that would require the written judgment. We need to scrutinize the written judgment, and we want to be very microscopic about it, in the sense that it is very relevant to sentence, because there were, from the conviction, 3 players who were the dominant factors in the judgment of the court. The first one was the company called Black Deck, which is an independent entity. And then the second and the third would be the accused persons themselves. From the notes that we have, we still do not have sufficient information on how the court dealt with the degree of participation or the extent of participation that we believe would be apparent from the written judgment. And that is relevant. And for argument's sake, my Lord and Lady Assessors, you might say, for example, yes, the medium was the company, but the company was not convicted. What was convicted were the accused persons. Clearly, obviously, those not convicted would have played a role. I don't think that is denied. But it is important that the convicted be able to see where, in terms of degree of participation, they are not challenged, the conviction is there. It is the degree of participation which is implied in paragraph K. That would be an example. Then we go to Section 8 of the sentencing guidelines, that also makes reference in terms of aggravation. And in fact, in the terms of submissions that have been made by the state already, the state is making submissions, and I'm referring you to paragraph G, my Lord and Lady Assessors, Section 8, paragraph G. It says, where the offender played a leading or a significant role in the commission of the offense. Now, what is in paragraph G would certainly be contained in the judgment of the conviction. Just like paragraph K of section 9. These are not facts to be introduced at the sentencing stage. These are facts that ought to emerge from a reading of the judgment. To what extent, what exactly is the convicting court said? These are issues that we would certainly need the written judgment, because the written judgment is complete in itself when it regards to those. I'm just picking the examples of the issues that we would wish. We are saying, even without these illustrations, it can only be fair that an accused person be given access to the judgment in a more stable format than in the oral submission. I would use, and if the court would forgive me for using the word stable, I'm not saying that the reading would be unstable. But the way we all operate is such that when you are reading something, you can underline it, you can slip over it, you can open it over and over again. We don't have such a thing. And we believe that will be necessary for that. Now, in terms of the law, it would appear that the request that is made by the applicants, and we so submit, is actually a legal right of the applicants to get the judgment. Why are we saying that's a legal right of the applicants to get a judgment? We say so because the right to a fair trial is just a bundle of rights. The Constitution and the rule of law simply says that the trial must be fair. And then it does not exhaust what would make a trial fair. And I have references that I wish to make. So in terms of our law here, there's the case of State versus Banana. State versus Banana, which is 2000, volume 1, Zimbabwe Law Reports, 607, page 607, and brackets, a Supreme Court judgment. That judgment discusses the right to a fair trial. And in that case, my Lord, the issue was whether or not pre-trial publicity, bad pre-trial publicity, might actually affect the right to a fair trial. And the Supreme Court went at length to explain the importance of a right to a fair trial and the fact that it cannot be exhausted in terms of what goes into it. Then I have two South African cases to refer the court to on fairness. The first one is a case called Bernstein versus Bester, N.O. Bernstein versus Bester. It's 1996, volume 2, SA 751. In brackets, CC is Constitutional Court. Perhaps the court could look at paragraph 105, and I think there will be other paragraphs that will be relevant. Then the second one is De Beer, N.O. versus North Central Local Council. Is 2002, volume 1, SA 429. 2002, volume 1, SA 429, again brackets CC for the Constitutional Court. The court could have a look at paragraph 11. There are several paragraphs there. But the point I'm making, my lords and learned assessors, is that you cannot exhaust the concept of a fair trial. what you have to do is you look at each request as it comes and see whether that request would fit the scheme of what would constitute fairness. So you don't need precedent. I say so with respect. You don't need precedent. You look at each request as it comes. And so that bundle of rights gets to be expanded as different situations arise. The request that is coming now, we respectively submit that it would fit into the scheme of what would constitute fairness, which is simply say, let us have the written judgment. Now, just to make that point, my Lord and learned assessors, I thought I should refer the court to the practice in international law. My learned friend for the state was asking me why I brought this book on international law, but it is to refer the court to a case on the fair trial. It is a case called, I would spell Jadhav case, Jadhav case, Jadhav, Jadhav, Jadhav case, and then in brackets it's India versus Pakistan. India versus Pakistan, we close brackets. International Court of Justice, you can just simply say it's judgment of 17 July 2019. This judgment is, of course, available simply by judgment of 17 July 2019. I need to just indicate why that judgment is important. It is looking at the right to a fair trial in Article 14 of the International Covenant on Civil and Political Rights. It says that the right to a fair trial is not exhausted by what is enumerated in legislation. In other words, the right to a fair trial is not exhausted by what is enumerated in legislation. And then what is enumerated is a bare minimum. And then it goes on to say that other rights may be added. Other rights may be added provided they share the essential characteristics of what is enumerated. I will try and go over that, my lords and my learned assessors. The importance of this case is that the right to a fair trial is not exhausted by what is enumerated in legislation. And secondly, what is enumerated in legislation is a bare minimum. And then thirdly, other rights may be added, provided they share the essential characteristics of what is enumerated. I have to confess, my Lord and learned assessors, that I had to look for this case because of my learned friend, Mr. Mabaudi, kept on saying when we met on Friday, that what is the legal basis? It is not in the Criminal Procedure and Evidence Act. It is not in his argument all over the place that we don't find it. It's not written somewhere that you need a judgment. This is the reason why I have to persuade the court that it's enough that our law says you have a right to a fair trial. That's enough. What will make a fair trial would be from day to day. What is fair, what we will record as fair, if this court says it's not part of fairness, it might say so. But I think that perhaps with time, the request made by the accused persons is clearly not out of this world. These are persons that are in custody, and they would be better off if they look at that, the judgment, you look at your underlying areas, you see what was my degree of participation, how do I then come, because the court kind of canvassed that, but we didn't then get all the details when the court was reading. So we need that, and that's the issue we are indicating. So on the basis of those submissions, my Lord, we would request that the court avails a written judgment to the accused persons before we proceed to the next stage. That's the request that we're making. And those were the submissions I've made. I want to close by saying that this application would then not be necessary if the court were then to say that it requires time to have the judgment made available and then provides the time. It might then mean that the matter would have to be postponed for the period that the court requires to have the judgment available, because the accused persons certainly require the judgment. They would prefer, that's the instructions they've given us, a situation where they could wait. They can wait because they are already in custody, but they need the judgment to make preparations for the next stage. I think those would be the submissions I make. I'm sorry, my Lord and learned assessors. I wanted to refer the court to Section 70. Sorry about that. Section 70, subsection 1, paragraph C. Section 70, subsection 1, paragraph C. That's the right that is given there, and I want to give it in the light of the submissions I've made. The right that is given there, any person accused of an offense has the following rights. C, to be given adequate time and facilities to prepare a defense.
And facility.
To be given adequate time and facilities to prepare a defense. My lords and land assessors, if that right is read narrowly, which would be wrong, one thinks that that right is only available before the trial. Our submission is that if the right is read properly, it is a right that continues throughout the trial. The trial ends with the sentence, pronouncement of sentence. And so the gap that exists between conviction and sentence provides yet another scope to prepare facilities. So we would read that right to mean that you are preparing for your defense if you are preparing for the sort of sentence that the state wants to call upon, because the state would it will certainly be calling for a particular sentence. So when you are saying, I want time to prepare for that, you are still promoting the right that is in Section 70, subsection 1, paragraph C. And even if that is not the reading, then that right would share the same characteristics with the request we are making. In other words, if you have a right to be given adequate time and facilities to prepare a defense, if that is not the right that we can utilize for the request we are making, we can still utilize that right as to support the right that we have requested, the right to get judgment, because it will share the same characteristics. You need facilities to prepare for your next stage. So we would want to defend ourselves now in the light of the fact that the state has already filed of record what it has termed aggravating features. And from that, the tone of those submissions, they are calling for the maximum sentence. I'm not sure what he's going to be saying when the time comes. But certainly we want to prepare for that. And the request we are making is not too much for the court. My Lord and Ladies, those are my submissions. Mr. Tro might add a brief, but I need to hear if the court has questions.
Yes. So is the judgment giving reasons for the verdict interlocutory?
The judgment, as far as we understand it, my Lord and Learned Assessors, it gives reasons for the conviction. And the reasons for the conviction are relevant for the sentencing. That is at least where we are coming from.
No, I understand you, but by description, is it a final judgment disposing of the case, or it is interlocutory?
My Lord, it would not be. We are consulting each other. Our view and our respect submission is that it's final in view of the sentencing guidelines. The sentencing guidelines give a gap. The conviction is final in itself. So it is final. Indeed, my Lord and learned assessors, a practice is emerging where you have two judgments. And that practice, we are all familiar with it from the bar, including my learned friend for the state. He's the one who's prosecuting all those matters. Where you get a judgment, a conviction, and then you get a sentencing judgment. The sentencing guidelines refer to what they call a sentencing judgment. My Lord, I need not refer to that provision, but it's quite clear that there has to be a sentencing judgment. That's in section 13. Indeed. Section 13 of the sentencing guideline. They refer to what they call a sentencing judgment.
So you are saying the judgment on the verdict concludes the case?
Indeed, it concludes the case. It's final. The conviction is there, stands. Then we get to the sentencing, and it is another judgment. If we want to make them one judgment, it will be contrary to the sentencing guidelines. That would be our submission. In other words, the conviction judgment is a final judgment, and it has to stand alone. And where a court combines them, we would go far to say that that would be incorrect with respect. So, and then my Lord and learned assessors, why I'm on that point. Also, you know that the rules then with respect do allow someone to appeal against conviction only, and so forth. I mean, things like that. So our submission is that these are two separate judgments, and the first judgment would be relevant for it becomes material for the second stage.
Yes, thank you very much, my Lord. Maybe if I can just add to that last submission for my learned colleague, that if one reads section 13 of the sentencing guidelines, in particular regard to subsection 2, which reads that the court shall write a sentencing judgment which follows as near as possible the structure prescribed in the second schedule. So that judgment, by requirement of the law, must be in a certain format, in a certain form, which has been given. And that format which is on the second schedule would not and does not give room, in my respectful view, for it to then be a composite judgment together with the judgment on the verdict, whether or not one is relating to the conviction on its own. So, because the statute mentions that the sentencing judgment is called a sentencing judgment, by implication, it follows, in my respectful view, that the sentencing judgment is a standalone judgment, which would then mean that the judgment on conviction is final as far as the question of whether or not a person is guilty is concerned. That would be my initial addition to that submission, my Lord. I also just wanted to add a few cases and the authorities which I would want to urge this honorable court to take into account in its determination of this particular matter, my Lord. I would refer to the case of State versus Makawa and another, 1991, Volume 1, Zimbabwe Law Reports, 142, a Supreme Court decision.
Is S versus?
S versus Makawa.
Citation?
1991, Volume 1, Zimbabwe Law Reports, 142, a Supreme Court judgment at 146. In that case, where the Supreme Court was looking at a scenario where, although as distinct from this particular case, the magistrate's court had not given detailed reasons of its judgment on conviction, and the court felt and held that that was a gross irregularity for the court to do so. The Supreme Court stated that it is a gross irregularity for a magistrate to omit to give reasons, which reasons remain stored in his or her mind without being committed to paper. The import of the submission that I make is that the Supreme Court held that whatever reasons that the court must give in a particular matter, those reasons must be reduced to paper. In other words, they must be in a written form. And when one looks, in my respectful view, to the pages to pages 198 and pages 199 of the Judge's Handbook by Professor G. Felto, which relates to reasons for judgment, which I would like to say would add to the valuation of the matters at hand. The import of the of what Professor G. Felto states in that when it relates to the reasons for judgment and their purpose and their link to sentencing is such that the detailed reasons of the conviction must exist, and if requested must exist in writing, and that they will be of paramount use to the accused persons. This is so, my Lord, I would submit and limit assessors that when one considers that even in the sentencing guidelines, it mentions that the factors that can be taken into account as aggravation or as mitigation, which are listed in those guidelines, they are not exhaustive. It says that for the avoidance of doubt, the reasons or the circumstances mentioned in section 8 and 9 are not exhaustive. I think this is number 9, section 9 of the sentencing guidelines. It says, for the avoidance of doubt, it is declared that the circumstances enumerated in section 8 and 9 as being aggravating or mitigating are not exhaustive, and that a court may find other circumstances in which any offense is committed to be either aggravating or mitigating for the purpose of arriving at an appropriate sentence. So what this section does is it opens up the circumstances which either party can really relate to in the commission of the offense. And those circumstances will be spelled out in the reasons of the judgment of conviction. This is where we can relate to and say this circumstance found by the court in convicting. We can then urge the court to say you could take this into account as either mitigating factor or aggravating circumstance. And it therefore follows, my Lord, in my respectful view, that it is not only desirable that the accused person be allowed to sift through in their own understanding. My Lord, I say this relating to the applicants in particular, because obviously there's a difference between how we appreciate and understand the judgment. If, for example, my Lord, if the court gives an oral judgment, we can follow and we can make heads and tails of what His Lordship and what the court was finding. But sometimes when we then go and interpret it to our clients, they may not really follow and understand. And they are urging this honorable court that they be given an opportunity to go through the judgment by their own selves and appreciate and then give us further instructions in respect of what factors they would read from it. I think if we're to speak from the bar, we do appreciate and we do understand the import of the judgment. But in some instances, our interpretations could differ in their own, and what we then relate to our clients could differ. Then the last point, my lord and learned assessors, that I really wanted to move in urging this honorable court relates to the aspect of prejudice, my lord. To say, we are urging this honorable court to balance the competing interests of the administration of justice on one end and the requirement by the accused persons to have sight of a written judgment where they can then give further instructions. The issue of prejudice comes in mind given the fact that the accused persons are already incarcerated and they are already in custody, which is an important factor that we believe should be taken into account. There would be no prejudice at all if the accused persons, if they elect to say would want to await the availing of the judgment so that we can then get into the next stage of the pre-sentencing. I do not see how that would prejudice the state if that request were to be afforded to the accused persons. I believe, my lord, those will be the only submissions that I want this court to take into account in addition to what we have.
Professor Madu, just to understand a few things. You said that the court previously agreed to make the judgment available. Under what circumstances?
My lord, the issue was that there were several circumstances. I know that at the time the state had threatened to file an application of forfeiture under the Money Laundering and Proceeds of Crime Act. And that was one of the main points that then came in the context of that. Indeed, the accused person said they would not be able to respond to that without a judgment. But I would wish to add, my lord, that that was not the only reason for the accused persons to request a judgment. My learned friends would be able to support that. It might not have come out very clearly in the interactions with the court. But that was those were the circumstances. It must still maintain the position that the accused persons would still have required a judgment, even in the absence of that. That was the easiest way of getting it. But, my lord, and my learned assessors, may I be permitted to say this? If the court would have provided a judgment in those circumstances, we do not, with respect, find a good reason why it cannot still provide the judgment, even though that circumstance has disappeared, the initial one. Because it would move. Because the impression it will create, my lord and learned assessors, is that the court would have acted because the state was involved. I don't think that would be, with respect, a good impression.
I'm saying we should not conflate the two. That request was made because the accused person said they would probably need it, maybe to attach it or whatever, in response to the state's intention to make an application in terms of the money laundering process of crime. Now that the application has fallen away, would it still be correct to say that the court is bound by its earlier indication, which was made in that context?
Thank you, my lord and learned assessors. There is one point with respect which continues then to come out. That point is that there was an undertaking to provide a judgment, although under given circumstances. In other words, the scope for providing the judgment was there, And all what we are saying is that we would rather pursue that scope. It might mean a change in the timetable, perhaps the time that it would require now that it's out. My learned friends for the state wanted to attach the judgment. We certainly wanted it to respond to that application, but also for purposes of the sentence. My Lord and land assessors, the court may need to take into account that that intimation by the state was part and parcel of the sentencing framework. In other words, it was going to be utilized as part of the sentence because they wanted the forfeiture as part of, I think, to be part of the sentencing regime. So it would not take away the fact that for some reason a judgment was to be made available.
But what was the court's attitude to the intention by the state and perhaps the accused person's attitude to that approach, that of embedding an application in terms of the money laundering process? Did the court consider that was correct, or did your clients consider that was the correct approach?
My Lord and Land Assessors, to be fair to the court had expressed itself on that point to say that it won't be an appropriate stance to take, and they wanted these two to be separate processes. We were in agreement with the court in that regard. But my Lord, having said that, that still doesn't take away the request by the accused persons.
Yes. You may have referred to it in passing, but you agree that the court indicated that the parties should take notes of the judgment.
Indeed, that was said by the court.
And that the judgment is on record.
My Lord, if I may just Thank you, my Lord, for the indulgence. The point that I wish to make, and I'm getting from my dear friends, is that that indication was given by the court that the judgment is on record. We then made an attempt to get a transcribed record, and up to now, that still hasn't been affirmed. It could have then been some substitute to what we are requesting. Perhaps at the very minimum, that could be what might be availed, but it is not available to the accused persons as we speak. But that request was made by our learned colleagues that are instructing us for the second accused. Mr. Mgia's firm did make
in writing.
Indeed, that's what I understand took place.
I would expect to find it on the platform because we are now paperless. Any request should be on the platform unless it was made through some other procedure.
I would not be able to say on my feet whether that was then done, but I know that...
Maybe I can interrupt. Who made the application? Mr. Mjetero?
It's Mr. Mgia.
Thank you. Thank you.
Thank you.
State?
My Lord and Honorable Processors, what the state noted from the application being made by my learned colleague is that they do concede that it is sui generis, and that they would want this honorable court to believe that there is no express provision dealing with this matter. That is an application that can be made after conviction and before sentence. This is the stage at which the court finds itself. That is not the position, my Lord, that the legislature had not envisaged a situation whereby an application could be made after conviction but before sentence. In part 17 of the Criminal Procedure and Evidence Act, that is on page 106, an application before sentence was envisaged and was envisaged by the legislature, and it was provided for in section 331, subsection 1 of the Criminal Procedure and Evidence Act, chapter 9.07, and it says, a person convicted of an offense by the High Court, whether on his plea of guilty or otherwise, may at any time before sentence apply to that court that judgment be arrested on the ground that the indictment does not disclose an offense. My Lord, this is the only provision which was found by the legislature to be available to a convicted person to detain the court from proceeding to sentence. And section 333, which deals with sentence in the High Court, subsection 1, it says, if an application for arrest of judgment is not made or is dismissed, the High Court may either pass sentence upon the convicted person forthwith or may discharge him on his recognizance as provided in part...
That section?
Section 333. Subsection 1. So, the only instance where the court cannot proceed to sentence a convicted accused person is provided for in section 331, subsection 1. And if there is no application in terms of that section, or if an application in terms of that section is dismissed, there is nothing that can stop this honorable court from proceeding to sentence the accused person. That is the only provision. And my learned colleagues do not concede that circumstances which can only detain the court from proceeding to sentence a convicted accused person before this court are provided for. They did not even mention the implication of these two sections, that is section 331 and section 333, but instead opted to make the application in terms of section 4 of SI 146 of 2023, which is not applicable at all. That section is only speaking to the application of the sentencing guidelines. The question that the state would like to pose before this court, before it answers, is whether this particular application is being made in terms of sentencing guidelines. The answer is no, not at all. The understanding of the court is that, of the state is that what the accused persons are saying, that before the court embarks on the sentencing guidelines, it is requesting for further information, something to that effect, because the judgment, my lord, was delivered to the accused persons before an open court, the court announced that the parties were supposed to take notes, and there was no undertaking by this honorable court that the court would thereafter release the judgment of the court before sentence. No such undertaking was made. Now, the judgment is there. My Lord and Honorable Assessors, extempo judgments are known to be delivered by these courts. Oral judgments are known to be delivered by these courts. My lady colleagues have considered that the judgment which was delivered by this honorable court was final. If that judgment was final, which was then delivered in the presence of the accused persons and with their legal practitioners taking notes, there is nothing that can preclude this court from proceeding to the next stage of pre-sentence procedures. Although my lady colleagues argue that they cannot proceed to sentence because the written judgment is not available. My Lord, I'm sure the notes that they took would suffice, and the judgment that was they have to proceed by way of the judgment that was delivered by this court, unless the state did not hear my learned colleagues to be indicating that they have reservations on the oral judgment, and hence they want it reduced into writing. That is not the reason for the application that the state got from the application by the accused persons. My lady colleague, Mr. Madubu, goes on to say he wants to ascertain the degree of participation and so forth. My Lord, those issues are matters of, if at all, there are issues of appeal, should they decide to take the matter on appeal. But otherwise, the reason why the court arrived at the conviction, they were all announced before this honorable court, and therefore, at this stage, they cannot start analyzing the judgment the way he has been doing. The cases that have been cited by my learned colleagues are not on point at all. They don't give this honorable court guidance on whether an application of this nature compelling this honorable court to release a written judgment can be made. It doesn't at all. An oral judgment would suffice. There is no provision that they can make an application compelling the court to release such a judgment. If at all, for instance, if the judgment had been delivered in terms of section 198 subsection 3 in a magistrate's court, a written judgment would have been appropriate under such circumstances, because such judgment would have been necessary for for accused persons to take the decision of the court on review to a higher court. But in this particular case, the applicants, they do not require the judgment for any particular reason at all, other than being a matter of preference. There is no reason that they want to take the decision of this court to a higher court, and hence the need for the written judgment to be upheld. That is not the case at all. This is just a matter of preference that is being exercised as a right by the accused persons. But when the judgment was delivered, the accused persons were in attendance. All the 5 lawyers for the 2 accused persons were in attendance. And the court had warned that there was need for notes to be taken, which was a clear indication that that was how the court was going to proceed to finalization of the case, in the absence of a written judgment. So, my Lord and Honorable Assessors, it is the state's contention that this particular application is not provided for to detain the Honorable Court from proceeding to sentencing. There was a media house which was clearly allowed to cover the proceedings of these proceedings, and it has been in attendance. If my learned colleagues and their clients were inclined to have a go at the reason for the conviction, they are at liberty to go to YouTube, where the proceedings were covered live. And they can sleep over it if they so wish, as Mr. Maduku has indicated that he would want to have a look at it, sleep over it, and you will be having the benefit of the tone of the court if he so desires during the sentence. So the judgment is available. It's not like it is not available. It is available in a video format, which they are at liberty to listen to at their own time, to enable them to proceed to the next stage, that is pre-sentence procedures in terms of Section 146, SI 146 of 2023. The application has no merit at all. It's not like my learned colleagues have no access to the reasons for conviction at all. And therefore, the accused person cannot be prejudiced in terms of Section 70, subsection 1C, as referred to by my learned colleague, Mr. Maduku, for the second accused person. So for those 2 reasons, that the application is unprecedented and unknown at law, and that it has no merit. The reasons for sentence, they are easily accessible, they are available. The application is without merit at all. And it is for those reasons that the state is humbly applying that the application to compel this court to render the judgment, to provide the judgment are without merit. In Mr. Madugdar is not in his order, he does not mention the nature of the order that he is seeking in his application. In this unique application, he doesn't say what his prayer is supposed to be. Is he giving this honorable court time frame within which to produce it? It is just an application without a prayer. And for that reason as well, his application is defective at law, and therefore it ought to be dismissed. That is all that the state wishes to say in response by Lord and Honorable Assessors.
Thank you, my Lord. I will just be very brief in the responses. First, I address the last point that has been made, which is that the application does not have a prayer. Unfortunately, it is not in writings oral. We were very clear what we are requesting the court to do. We were requesting that the pre-sentencing process be stayed pending the availability of the written judgment to the accused persons. The court making available written judgment to the accused persons. Then the sentencing process is stayed. I thought that was clear. That is the request, that is the order that we are seeking from the court. Then there is the submission made in respect of Section 331 of the Criminal Procedure and Evidence Act. That section has no relevance to the proceedings. Section 331 is very specific as to why it is in the law. Section 331 only arises where a person wants to change the conviction judgment. In other words, you want to what it is simply saying as a matter of law, my Lord and Lady Assessors, is that unless there is something that affects the conviction judgment, the court must proceed to sentence. And the only way in which you can affect the conviction judgment, if you seek to arrest it on the basis that it is inconsistent with the indictment or that the indictment was invalid. So it doesn't arise. Here we are not challenging the conviction. We actually want to proceed to the next stage. But we are saying to enable us to participate meaningfully in the next stage and to protect our rights in the next stage, we would want the facility of having access to the written judgment. So 331, 333 that my learned friend was referring to does not arise. And it cannot be correct to say that unless you are arresting the judgment, you cannot make any other appropriate application. Then thirdly, it is true that we have considered that there are no express provisions, but that doesn't mean that there is provision. We have said there are no express provisions, but there are implied provisions. Section 4 of the regulations, the guidelines, Section 4, and I did say by necessary implication and by unavoidable implication. So either you have express provision or you have implied provisions. This would be implied that there is an implied right to accused persons to make the application that we have made. Then we finally say that from a practical point of view, our law has not yet permitted a reliance on videos as judgment. There is no provision for that. What we would have to have something that we can touch, it's either a written judgment or a transcript. But my learned friend is an invitation that we can go and watch YouTube and take notes from there. It's completely contrary to law. And in any case, the accused persons have no access to YouTube. They are in custody. And this takes me to the point that I made in Mr. Jetero very ably added, is that we represent the accused persons, and the rights that are at stake are the rights of the accused persons. It is the accused persons that are under trial. They are represented by counsel, correct, but we cannot take away the role that they play in their own trial, which role requires them to participate. In this case, they need to read the judgment, assist in the formulation of their case, then instruct lawyers properly. I think that is a point that is forgotten by my learned friends in that regard. Those be my submissions. Please, my learned friend, if I have left a point, I have no other points to respond to. The cases that we have cited, I believe very strongly, my Lord and learned assessor, that my learned friend has not understood where we're coming from. He has not answered the question of fairness, which is the whole basis of our application, that to enable that there be a fair trial. That would be our submission. My learned friend might add one word.
He doesn't, he has nothing to add. He shook his head. You just were not looking at him. Anyway, thank you very much. Pero there's a real possibility that we may be ready with our ruling to be delivered ex tempore in this court. Although this is a legal point, I'm allowed to confer with assessors and perhaps take time to reflect and consider the submissions made. So this is almost time for lunch. We can meet at 2:30 for the ruling. In the event that there are any challenges, then they will be communicated. The court will adjourn.